So my name's Hannah Taylor. I work for a service called Comma at Stockport Family, the Stockport Council. We sit within children's services, and we support parents who are at risk of repeat care proceedings and repeat separation from their children. So in terms of care proceedings and the challenges that parents with learning disabilities face, I think care proceedings present significant challenges for all parents, but particularly parents with learning disabilities. One of the main issues that we see is that parents often have undiagnosed learning disabilities. So often they've been involved with children's services for a number of years. They've been in child need processes, child protection processes, often in public law outline. There's been improvements and then things have fallen back. There's often worries about parents' capacity to sustain change. And when it comes into the court arena, I think often social workers recognise that that parent has a learning need. But because of the complexity of people, I think it becomes very complicated in terms of, these particular parents have often had a trauma history. So as children, they have experienced abuse themselves. And because of that, they've had behaviours that have been put down to trauma rather than a learning need. So when they come into court, often what happens is that they'll get a cognitive assessment and a psychological assessment. And the cognitive assessment will identify that there is a learning need there, or a learning disability. And the psychological assessment will identify that there's a mental health need there. The two have often gone missed because they've been confused with each other. So what happens is when we get into the proceedings arena, that there'll be a diagnosis at that point. And at that point, the parent can then access things like an assessment with adult services because they have that diagnosis. But care proceedings run 26 weeks. So at that point, by the time that specialist assessment's been completed, they have a diagnosis, they're left with this tiny time frame, which they then have to evidence significant change and an ability to sustain that change. And often where therapeutic support has been offered, or a need for specialist services around their learning disability, the parent doesn't have the time to evidence their commitment to or sustained working with those services within that time frame for care proceedings. It's as though that needs to happen so much earlier, so that the parent has, right back when it's first recognised that a parent has learning disabilities, before it even enters care proceedings, so that we can really understand, what is this parent's needs, how do we assess them in a way that they can engage fully, and then we can make sure that they have the right services in place before to test whether that parent is able, with the right support, to parent their children safely. But unfortunately, cognitive assessments, they're incredibly expensive. There's massive waiting lists at the moment for them, even for once parents are in care proceedings. They're waiting for quite a long time for those assessments to come to fruition, just because of the capacity of the psychologists. The way that the language is used and the formality of public law proceedings can be really intimidating for all parents. But for parents with learning disabilities, they can struggle significantly to understand what's actually happening. Also, people with learning disabilities often need independent advocacy. And again, that was an outcome, a best practice outcome that came from the 2021 guidance, working together with Parents Network. That is really difficult to get. I think often the solicitor is seen as an independent advocate, of course, but in terms of really advocating with social care, that can be really difficult, because a lot of legal aid solicitors are incredibly busy. They have lots and lots of cases all of the time. Parents with learning disabilities often need information repeated to them continually, and solicitors don't always have the capacity to be able to do that. So in terms of the specific support that we offer to parents with learning disabilities during care proceedings, we attend court with them, we help take notes for them, we talk to them afterwards about what happened, what the decisions were, any recommendations that were made in terms of what they need to do at the end of the proceedings. We'll repeat that to them. We have the time that parents will continually ring us and ask for us to repeat that information, which we will. If there has been assessments around the learning needs that have outlined how that information should be communicated to them, we would follow that advice to make sure that the parent has the best possible opportunity to understand what's taken place. The experience of women who have children removed isn't really fully understood, and less so for parents with learning disabilities who, understand those experiences differently and often don't fully understand why those decisions have been made. So it's important for services to hold parents emotionally. I think, that's the ethical responsibility. These parents are in such pain. And I think what parents report is that they need to be seen. They need that pain to be felt by other people and to be recognised. And that it shouldn't be assumed that just because their child is somewhere else and safe, that there isn't an experience of grief and loss for those parents, because there truly is.